We're here this morning for our policy meeting. We're going to begin this morning by Deputy Director Kleiman discuss HR 111. Turn that over to him at this point and welcome everybody this morning.
Good morning. Thank you. This morning, we're going to be reviewing the work that's been done by Commission staff over the last 3 months, but to lead up to that work, I thought it would be useful to review some of the material that was presented at the March policy meeting because they're intimately connected, especially when we think about units of analysis and how we approach this from a Commission perspective of defining different aspects of the study. It's worth also noting that the data for this study comes from a number of different sources. The primary focus of the beginning presentation here will be on data that the Commission received from the Administrative Office of Pennsylvania Courts. Brett will be talking about additional data sources that were used for the recidivism analysis as well. The mandate that we received through the resolution was to comprehensively study and investigate the prosecution and sentencing of violations of Pennsylvania's Uniform Firearm Act of 1995 in this Commonwealth. For this resolution, we received 6 different directives, and those directives were to look at how those cases were moving through the system and where they were withdrawn or dismissed as they progressed, what we typically are referred to as an attrition type of analysis. We're going to look at what type of sentences that individuals with these charges receive. We're going to look at conformity to the guidelines. And then the new material that Brett will be going through will be focused on the last 2 directives of the resolution, focused on recidivism aspects of individuals who have different profiles for either different types of VUFA charges, but the way those cases may have been handled. For example, if a case was withdrawn, what is the recidivism rate for that type of individual whose case was withdrawn in either the lower court or the upper court, as an example? We looked at all cases that were related to Title 18, Chapter 61 with VUFA charges between 2000 filed in the Administrative Office of the Court data between 2015 and 2020. So just as a reminder, our unit of analysis we're looking at for this part of the study is dockets. So dockets that include a VUFA charge. If we remember previously, on average, there were about 2 VUFA charges per docket and 5 or 6 additional charges on top of those VUFA charges within these dockets. So our original sample here is 51,205 dockets that include a VUFA charge filed between that period of 2015, January 1st, 2015 to December 31st, 2020. We looked at those that were filed in municipal court, roughly 18,000, and those filed in the magisterial district court of 33,000. On average, on average, there's roughly 8,000 dockets filed per year over this period. Pardon me for one moment and it was just notable that there was an increase statewide in 2020 in the number of dockets filed, but an average of about 8,500 per year over that period. In advance. Oops, got it. At the previous March meeting, we presented the information by filings per 100,000 population. And I just want to note to you in that when we were reviewing that information after the meeting, there was a mistake in the calculations. And you might remember that we showed that in the 3rd class county, there was a significantly high proportion of cases filed per population. We essentially used the wrong denominator, which inflated that number. And as you could see here, that the rate for dockets that include all VUFA any type of VUFA. I'm sorry, all kinds of things are popping up here. Dockets that include felony 1, felony 2 VUFAs and dockets that are co-charged with violence. We see that the highest rate per population is in the first class county. Next highest is in the second class county. And the rate, it's notable in the first class county is essentially 3 times as large for all of these different groupings than it is for the statewide average. So we have an average, for example, in the dockets that contain VUFA charges, a rate of about 180 filings per 100,000 population in the first compared to 65 per 100,000 statewide. And it's just worth noting again that from a unit of analysis perspective, we were looking at 3 different types of combinations here. Dockets which included any VUFA charge, dockets that included a felony 1 or felony 2 VUFA charge, and dockets with a VUFA charge that are co-charged with violence. And that will be a unit of analysis that we'll see throughout, and that will extend to the recidivism analysis that Brett will work on as well.
Hey, Matt, could you talk just a minute about how you determine violence? When you say it's co-charged with violence, could you just describe that?
Sure. In the resolution itself, there's a specific set of statutes that define what violence is. So we use that definition that was in the resolution to define violence. So as I mentioned, we went through and we took a look at this idea of attrition. So a number of these cases would be still pending. We're looking at, of course, cases that are filed up through December 31st, 2020. So it could have been filed basically in December 2020, and there would be no disposition for that type of case. I do want to note, so for the purposes of this analysis, we remove the pending cases, but for the recidivism analysis, we consider those pending cases because those are time since the arrest and since filing that the person could have recidivated. And Brett will get into that briefly. But, and I also should note, and we mentioned this in March, that the high rate of pending could be a function here of COVID-related issues and court disruptions in 2020, when we're looking, especially in Philadelphia, at 17% of, in the lower court, cases are pending. So when we look at the dispositions in the lower court here, this is the dispositions out of non-pending cases. And we see statewide roughly 10% of dockets, this is for all VUFA dockets, are withdrawn, 5% are dismissed, and roughly 80% statewide are bound over. And we see some variation in the bind over rates, ranging from 77 to 88%. Second class A, 88% are bound over. So there's a little bit of variation in the withdrawn and dismissal rates, but for the most part, they're pretty consistent, again, between 80 to 85% bound over from lower court to upper court. But it's important to note these withdrawals and dismissals, again, is something that Brett will utilize in the recidivism analysis to see what happens to those individuals when those cases are disposed of without judgment in the lower court. So as I mentioned, in municipal court, 80% are bound over. For magisterial district court, 82% are bound over. And now we can do a similar investigation or look into how those cases, what the attrition is like for those cases in the court of common pleas. So an additional 17% are are pending, which leaves us with 26,000 dockets that are non-pending. Of these, 1% are dismissed, 1% are withdrawn, 10% are null prost. And so when we take a look here, this gives us that same set of data, but gives us some information now at the county class level. And I should note also that our analyses, as we progress both through this attrition analysis and the recidivism analysis, we're making distinctions or comparisons between statewide and the county classes. That's the way we're drilling down inside of this, as well as a number of others by case types. Brett will talk about later, for example, about 6105. So dockets containing 6105, but we primarily stay at the statewide or the county class level. So this paints the picture of the way that dockets are disposed in 2015 to 2020. But what it doesn't show is the dynamic aspect of this over time. So when we look at the guilty rates, again, we see 83% is the average statewide. First class is 77%, second class is 78%. In comparison, second class A is 91% as a disposition of guilty for those dockets, including VUFA. So what the next set of slides show is the percentage of guilty by year by county class. So each bar represents a year. So 2015 to 2020. So we see statewide that 83% of cases that are disposed of dockets involving with VUFA charges have a guilty verdict. And we see then there's a decline over time statewide. So we can look at these by kind of a cluster of different county classes. So that second class A and third class have the highest rate of guilty, 91 and 88 for their dispositions. Fourth class and fifth through eighth classes have the next highest at 82 and 86. And while there's some fluctuations and a little bit of decline we see in 2020 in the fourth class and second class A, it's not as dramatic as that statewide average was. So when we take a look then at first class and second class counties, we see that the average is 77 and 78%, but that guilty rate in the first class declines dramatically. And we see a somewhat of a decline as well in the second class. So when we dive into this data, and apologies for the size of this, but let me just walk you through what this is showing. We see that the percent guilty declines. So in the first class, it goes from 88% in 2015 to 84, down to 66% in 2020. Second class goes from 84% and then begins to decline to the upper 70% to 72% in 2020. And if we wanted to see what the driver of that decline was, we could take a look at the percent null prost. So if we were to look at the first class county, the percent of dispositions by null pros was 7% in 2015, 10 to 15% from 2016 to 2018, and then goes up to 21% in 2020, with a somewhat similar story in the second class county as well, going up to 18%. So we see a difference here, particularly in first class and second class counties, in terms of the way the dockets with VUFA charges are being disposed of in the upper court. So as I mentioned, statewide, 83% of these VUFA dockets are resolved with a guilty disposition. And so we want to look at the sentences now, the last two parts of this first directive that we primarily covered again in the March meeting. And then I'll shortly turn it over to Brett for the new material on recidivism. This figure now shows the dockets with guilty verdicts, what their outcomes are. And we're looking only here at prison, jail, and probation. So these percentages don't sum to 100, but they're pretty close to 100%. So we see that for all VUFA dockets, just slightly over a third received prison, roughly a quarter received jail, and a little over a quarter received probation. And as that mix of charges, including felony 1, felony 2 VUFA charges, and those co-charged with violence, we see that the proportion of those sentenced to prison increases pretty dramatically from 38% to 60%, then almost up to 3/4 for those co-charged with violence. And with those co-charged with violence, it's just worth noting that roughly 90% receive a confinement sentence. Oops. So these last set of slides now talk and look at conformity to the guidelines. How do judges sentence these dockets or these cases? relative to the recommendation. So I'll just note that for the last two, the previous slide and this slide, we're now using a Sentencing Commission data to look at. That's the AOPC data, does not have the guideline recommendations and the prior record score and so forth. So it's a smaller sample of 13,000 for any VUFA case that we have here. And what's notable here is that overall, 43% of any VUFA docket statewide are sentenced within the standard range, about a quarter within the mitigated range, and a quarter below. The rates for the outside below and the within mitigated are slightly higher in the first class county, but again, noticeably higher in the second class county, so that 35% received within mitigated sentences and 40% are outside below, with only 34% within the standard range. So when we look at now for dockets containing felony 1 and felony 2, we see that it's even more magnified here in the second regarding the proportion of cases that are sentenced that receive a sentence outside and below. So that it's 70% within the mitigated is 20%, and only 9% are within the standard range, where statewide we had 34% for this type of docket.
Can I just jump in with a quick question? I just want to make sure I understand this correctly. So are you saying that in the second class county, which is Allegheny County, right? 90% of the VUFA sentences that were an F1 or F2 were below the standard range of the guidelines?
Correct.
Thanks.
Yeah, and it is worth noting as we move forward to talking about the report, one of our recommendations will be that there's possibility for the commission to extend some of our work. And we haven't had the opportunity to speak to any of the judicial or prosecutorial actors in any of the counties to understand or unpack what might be going on. So this is strictly a data-driven picture without any qualitative or interviews kind of background to provide some explanation of what may or may not be happening to explain this. And then those co-charged with violence, we see a similar picture, but much less in terms of those below or within the mitigated. But again, a higher proportion in the second class county.
Excuse me, Matt, this is Judge Tucker. This is going back to the chairman's question. So I'm trying to extrapolate the first class, Philadelphia County. So my reading of this indicates that it would be somewhere in the neighborhood of around 60% of the cases are.
Matt, could you go back one slide? I think that's where Judge Tucker was.
This one?
That slide, Judge?
Yes.
Yeah.
So I'm looking at outside below, as well as within the mitigated, and I'm trying to combine them. I see it appears to be outside below would be what, 50%? And then I'm adding the within mitigated, and that would appear to be somewhere about 20%. Is that correct?
Yeah, so the precise numbers are 51 and 19. So if we combine them, it would be 70%.
70.
In comparison, the statewide average is 42 and 20 or 62%. So slightly higher if we combine that compared to the state average.
When you say slightly higher, we're talking about what, 12%?
About 8%, I think, 62 to 70.
Great, thank you.
And Matt, just as a reminder on this, the starting point of this are the non-pending cases. So these are cases where we've gone through that attrition model, null pros, all of those are removed, and pending cases are removed. So these are where there's a final disposition of the case, and then in this case, a sentence, and then we're using sentencing guideline information to inform the conformity to the guidelines.
Correct. Thanks, Mark. It's also worth noting that because this is using PCS data, and then again, we have this smaller subset of felony 1, felony 2, that there's 940 dispositions in the second class that there would be a sentence for over that 5-year period. So it's a large number, but not a tremendous number. And then going back to the co-charge with violence, one last point, sorry, Judge, is just to note that the aggravated and outside above are very rare, but in the first class, they're slightly higher than the statewide average. They're 8% are within the aggravated range and 11% outside above compared to the state average of 6 and 7%. In the second, it's 2% and 3% respectively. So when they are above the standard range, the first class county actually has a higher proportion for these co-charged with violence. But please note again, the ends are smaller in many of those county classes because of the rarity of co-charged with violence being sentenced, the non-pending dispositions here in the Sentencing Commission data.
Thank
Judge,
you.
I'm sorry.
Thank you.
So question on when they're outside below, I know that a judge needs to put a reason on the record when they go outside completely, but don't they have to log that in also when they plug in their reason for going outside? Is that in with the information that the commission has?
It is. And we took a look at those reasons and they were somewhat vague and not telling us a story that was necessarily worth reporting out to the commission.
That was my question. Thank you.
Okay. So
Just
that
to follow up on
yeah.
that quickly, so I understand, is that when they report that, that's not with like a drop down where they have to pick from pre-established options? That's just a text that they fill in?
Yeah, there's 3 ways in which courts can report that. So first, if it's a departure below, the application SGS Web requires courts to provide a reason. And the first level is that pull down menu of common reasons, so they can click on those. The second is a small text field, and the third is basically a cut and paste. And so we look first to the pull down list to see what we can sort of aggregate there. And then we look at any comments beyond that. But it was pretty limited in this case. So there's a requirement to report some reason. We have that, but it might be pretty basic, like an agreement of the parties or something like that.
So again, this material that I just shared was material that we presented previously at the March Commission meeting, at the policy meeting, and now I'm going to turn it over to Brett, who's going to be using, again, some of these framing issues and some of the unit of analyses. So we could see, for example, in lower court, if we remember, about 15% are withdrawn or dismissed, giving some context to the recidivism analyses, and then looking at what happens to individuals who are under supervision. And so with that, I'll turn it over to Brett Miller.
Thanks, Matt. So now we'll move on to directives 5 and 6 of the resolution. There were 6 total resolutions. At the March meeting, Matt and Miranda went into a lot of detail to try to put a spotlight onto some of the issues related to dispositions at both the lower courts and upper courts, sentencing practices, which we just looked at, and some of the major decision points that go along with these VUFA cases, including charging practices and packaging charges into a set of charges for a docket. So what I want to do as we go through these last 2 directives is to sort of pick up those threads that Matt started and try to carry those through to look at their final recidivistic outcomes. So we'll be looking at a lot of the same outcomes, or a lot of the same dispositions, units of analysis, and again, trying to follow those decision points through to see what outcomes come as a result of the various decision maker practices throughout the courts. So first we'll look at the recidivism analysis. And to build our recidivism sample, first we took 52,000 cases that Matt and Miranda presented from the first round of analysis. And we've taken that data from Administrative Office of Pennsylvania Courts, and then we tied that to information from the Department of Corrections on DOC release dates, information from the Parole Board on state parole supervision, and also data from the commission to look at sentencing conformity and the outcomes related to those. And finally, we used information from the ER2P system, which is a new system hosted by JNet, where they try to collect the county level supervision data from across all counties and tie it together into a state system. So I'll describe that more as we get to the county supervision data. But it's an interesting and unique tool that is, as I mentioned, relatively new, but we'll see what results we can get out of that as well. So just looking at our sample that we collected from 2015 to 2020, the cases that we're looking at are any docket filed within 2015 to 2020 that contained a VUFA charge. So we'll break them out again as Matt did for any VUFA charge. Then we'll look specifically at those F1 and F2 VUFA charges. And then finally, we'll look at dockets that were co-charged with a violent offense. So in our final sample for recidivistic analysis, we ended up with 43,279 individuals, predominantly male, 92%, and 56% Black, 41% white. So this is consistent with research we've conducted in the past and seen elsewhere, where we've seen that these VUFA offenses are predominantly committed by Black offenders and typically male and typically young. And then looking at the breakdown by county classes, again, we see the same results we saw from Matt's analysis, where the highest proportion of these cases are coming from the larger county classes. So county classes 1, 2, and 2A are where the majority of these cases are coming from. And then just to sort of follow along the trend of the attrition that Matt presented, we took our sample, which is 43,000, slightly smaller than the initial sample. And we tried to follow that through from the time of filing, looking at attrition, whether it was through dismissed cases, withdrawals, or null prost, and following that through to common pleas dispositions. So we started out with 43,000. Out of the non-pending dispositions, as Matt showed, over 80% of those were bound over to common pleas. 15% of those were attrition, which, as I mentioned, would be null prost, withdrawn, dismissed. And 4% of those were resolved in lower court, meaning they had their final disposition at lower court. Out of the 80% bound over to common pleas, we were left with 31,000 common pleas cases. And 85% of those cases resulted in convictions. Again, at the upper courts, we did see a fair amount of attrition with 12%, and only 3% received acquittals at common pleas. So I should mention here that any study of recidivism is very heavily dependent on the data available, but also it's very dependent on the definitions that are used. So we've gone and looked at a number of different recidivistic studies. As you look at these studies, you'll find a wide range of recidivism rates and vastly different units of analyses and time ranges for tracking recidivism. So in a DOC study from 2013, they looked at 3-year post-release rates for state prison inmates, they found that recidivism was over 50% for Blacks, 45% for whites. In a study from 2018 by the Philadelphia Reentry Coalition, they looked at 1 year rearrest rates. So their recidivism rates were lower at 32% for Blacks, 40% for whites. And just last year, the US Department of Justice completed a study on recidivism for state prisoners across 34 states. They looked at 3-year rates for any arrest and again found general recidivism rates upwards of 50 to 60%. So as you can see, those rates vary dramatically across studies, and you'll see when we get to our results that our rates are slightly lower, and that's related to the definition of recidivism as it's spelled out in the resolution. So again, we're starting by only looking at VUFA arrests from 2015 to 2020. And our definition of recidivism is looking for the first new arrest, or in this case, a new docket filing for a new VUFA offense or for a violent offense. So the key to remember here is that if an inmate was released, they went out and committed retail theft, we're not going to include that in this analysis. We would skip over that rearrest and keep searching for a new arrest for a gun charge. Unfortunately, comprehensive arrest data was not available for this study. Part of that is just due to the Pennsylvania State Police policy that we're not able to request comprehensive data on a given offense. So we weren't able to get just a blanket request for all arrest data. So instead, what we've used as a proxy for arrest is any new docket filed at the lower courts, so magisterial or municipal court. And then, as I mentioned, recidivism for this study is defined as any new docket filed that contains either a VUFA offense or a violent offense, or both. The other key part here is how long do you track recidivism for? So in many studies, one of the common time periods to look at recidivism for is 3 years, commonly cited. Another common time period is 1 year. So in this study, we've decided to look at 3 different time periods for measuring recidivism. First is the first 6 months, either post-release or immediately after disposition for non-confinement sentences. Then we'll look at 1 year recidivism rates and finally 3-year rates. For those who are serving confinement sentences, our tracking period doesn't begin until that individual was released from their confinement term. For non-confinement sentences, like I said, our tracking begins immediately post-sentence date. And that's if they were denied bail, meaning that they were incarcerated pre-trial, then we started the tracking period immediately after sentence date. If they were denied, if they were granted pretrial release, then we started their tracking period initially after the filing date, as they would have been in the community the entire time from the time of filing charges.
Brett, could you just clarify that again? So it says tracking begins at the date of sentence if pretrial release was denied. So the idea was the person was detained, they're now before the court for sentencing, and then at the point of sentencing is when, if they were placed on probation, let's say, you'd start the clock. And then the other one is if the person was arrested and pretrial release was granted, it would start at effectively the arrest date or the MDJ preliminary arraignment date and move forward. So it's covering both the pre-trial period as well as the post-disposition and sentence period, right?
Correct.
Okay. And those are 2 different things you looked at, right? You looked at failures or recidivism after sentencing, but you also looked at failures while the person was in the community before final disposition and sentencing of the case.
Correct. So the idea is for those who were granted bail, we assumed that they were out in the community that entire time. So we begin our recidivism tracking or our pretrial tracking immediately at the time of filing of the first charges. And so obviously, depending on confinement sentences and the date of the first arrest, we have different lengths of time that we're able to track different people. So for those who might have had charges filed in 2015, served a 3-year confinement sentence, that takes you up to 2018. Our study ended in 2020, so the longest we possibly could have followed that individual would have been 2 years from 18 to 20. So again,
Let me just add one point to that. As Brett mentioned in other studies of recidivism, sometimes if you're looking, let's say, at a program, you make sure you track individuals for the same duration. So everybody would have been tracked for 3 years, and then we have a common tracking time for everybody involved. Here, as Brett's noting, there's variation. Again, if the case was filed in December 15th, 2020, and they were not held pre-trial, we would track them for 15 days. So we're taking into different combinations here based on when the filing date was, confinement, bail conditions, of what amount of time we're actually tracking them.
So across the 6 years, 2015, all the way inclusive of all of 2020, we had 6 total years of the study. And so our average tracking period where people were available to be tracked for recidivism was about 3 years, which makes sense. It's roughly half of the time period of the study. And before we get into the results here, I just want to remind you of what the questions are that we're trying to answer here based on the resolution and then based off of our findings from the first 4 directives. These are the things we kind of want to bring to a close and find a conclusion to. Number 1, do the prosecutorial and or judicial decisions that are made either at the lower courts or the upper courts, but they have an effect on recidivistic outcomes. So these would be the dismissals, the null pros, the withdrawn, plea deals. Do these impact recidivism? Next, does the specific charge or type of VUFA offense affect recidivism? So we know that some of the common charges are 6105 for illegal possession of a firearm, 6108 possession of a firearm in Philadelphia, and a couple other specifics that were the top VUFA charges. We want to take a look and see, is there any difference in recidivistic outcomes among those different charge types? Next, we want to sort of look across the state and try to determine if there's any differences either geographically or at the county level in terms of urban versus rural. Are there any differences across the state in terms of recidivism? Next, are there any racial disparities in the recidivistic outcomes that we see for these VUFA charges? And finally, we just saw the results that Matt presented on the number of mitigated or below departure sentences. So what we want to know is, does that have an impact on recidivism? So with that, we can move into our results here. I'll just walk you through this graphic here. We'll try to follow this theme as we go through all the various different cuts of the data, look at different analyses. But in general, this is the way we'll be presenting the recidivism rates. So the first is our 3 different docket types. The first was any VUFA offense. Second is an F1 or an F2 VUFA charge included in the docket. And the third is any docket co-charged with violence. The recidivism rates will be measured by each of these groups. And again, we'll be looking at time periods of 6 months, 1 year, and 3 years. Just looking at the first category, which is all VUFA dockets. So this would be our entire sample, or 43,000 sample that we had for recidivism analysis. And if you look across these rates, you'll see that the first thing you'll see is that these rates are lower than some of the rates that I mentioned from previous studies. The primary reason for that, again, is that we have a different definition of recidivism here, where we're not looking at any new filing, but we're only looking at an initial filing for a VUFA charge and a subsequent filing for a VUFA charge. So that brings down the general recidivism rate across all three of these time periods. But as you see, as you go across from 6 months, 1 year to 3 years, we start off relatively low in the first 6 months at 3.8%. Then at the 1 year mark, the rate is about doubled. So from six months to 1 year, we're doubling the time period, and the rates are about doubled as well. Then moving from the 1 year to the 3 year, you can see the rates have tripled at this point from the 1 year. Again, time period has tripled and the rate has tripled. But what that shows us is that the risk of recidivism appears to be even or uniform across all time periods. So there is no spike in the first 6 months or at any other time period. It appears that in this sample, whatever the inherent rate of risk is, it seems to be the same across all time periods.
Hey, Brett, if I could just offer a comment there. This is one of those things as we've been looking at recidivism in a lot of different settings. And if you look at the research out there, there's a lot of talk about that most critical time, especially for those who are incarcerated, is the immediate release following incarceration. But as Brett said, just looking at this, we see sort of a straight line in terms of the recidivism rate across time periods. So that seems a bit different than what you see more generally. And one of the things to look at is, are there differences for probation dispositions when a person's immediately on the street versus confinement when someone has been in an institution and is now being released to the community during reentry? Are there different risk levels there? But at least from this starting point, it's a straight line, which is a bit different than what you'd expect. Thanks.
And the other thing I'll mention is that right now we're looking at the combination of every disposition type, every sanction type. So this is sort of the overall combined rate is shown in this first column here. Now, if you look at the comparison between the different groupings of dockets that we've been looking at through this whole study, you can see that the rate of recidivism does rise as dockets get more serious. We start with our baseline rate of 20%, jumps up to 26% for F1 or F2 VUFAs. And for a docket co-charged with violence, we're up to 28, close to 29%. And as you look down through the various rows for each of the county classes, what you'll see is that trend continues across all county classes. Now, just looking at the 3-year rates for all VUFA dockets, you can see that there's a clear trend here among county classes. I mentioned earlier that the highest proportion of cases are coming from our larger county classes, essentially the first through the third county classes. And what we see is those are the same areas where we have the highest rates of recidivism, with the highest being county class 1, almost 30%. And then if you look at some of our more urban counties, more rural counties, that 3-year rate drops all the way down to close to 10%. Now moving to look at the specific VUFA charges and if we see any differences in rates by the various charges. What we did here is we're just showing the top 3 charges here. These were the 3 most common charges. We looked at the others as well and didn't find a real strong trend or difference from those other 3, or from these 3 compared to the rest. But you will see is that again, the rates here are increasing across time as we would expect, but they're relatively equivalent across each of these three offense types. The one exception that I'll note here is that if you look at the 6105s and you look specifically only at the felony 6105 charges, there were 661 of those cases. And out of those cases, there was a 52% recidivism rate within 3 years. And that, breaking down all of these charges by grades, by various details, that was really the only spot we found where there was a substantial difference based on the specific charge that was filed.
Hey, Brett, could you remind members of the three offenses that you have listed there? 6105, 6106, and 6108.
So 6105 is related to unauthorized possession of a firearm. There are different versions of it. There's the felony version is based on someone who has previously been convicted of a violent offense or of a serious felony drug offense. So those felony 6105s, that is a different population of individuals. Not anyone can be charged with a felony 6105. It would have to mean that you had already been convicted of a serious offense. Then there's a misdemeanor version of that, which would be providing firearms or receiving firearms from one of those unauthorized individuals. 6106, I believe, is also related to
Yes,
unauthorized.
firearm not to be possessed or carried without a license, rather.
Right. And then the 6108 is the Philadelphia specific statute that's related to firearm possession within Philadelphia. Now returning to Matt's analysis on the various dispositions at each level of the courts, we'll take a closer look at the lower court dispositions and the impact that those may have on recidivistic outcomes. So again, we're only looking at 3 outcomes here. These were the 3 most common cases bound over to common pleas courts. Again, over 80% of these cases were bound over to common courts. The second is dismissed, the third withdrawn. So we would categorize the dismissed and the withdrawn categories as decisions that are being made at the court level that either there is not enough evidence or that this case does not rise to the level to pursue conviction. And looking specifically at the dismissed and withdrawn, we can see that they are associated with a slight increase in overall recidivism rates as compared to the dockets that are bound over to common pleas. One caveat here, again, is these only represent less than 20% of the overall cases, but these lower court dismissals and withdrawn dockets do lead to a slightly higher recidivism rate across all time periods. And you'll notice that the gap actually shrinks a bit over time here when we look at this metric. Within 1 year, we actually see that we have a substantially higher rate of recidivism for withdrawn cases within the first year. So if you look at the top bold row, that's our overall statewide rate. Looking at 1 year, withdrawn cases for all VUFA dockets are approximately 50% higher for those withdrawn dockets. Now moving on to the common pleas dispositions. Again, we're analyzing the 3 most common dispositions from the common pleas courts. Those are conviction, acquittals, and null prost. We saw from Matt's research that over 85% of these cases, once they get to common pleas, do result in convictions. And then again, looking at court decisions resulting in attrition of the case, we see that those cases that receive a null pros disposition at common pleas do tend to have higher recidivism rates within the first year. This is similar to what we saw with the withdrawn cases at the lower courts. One thing we do notice, though, is that this trend does not seem to hold for those cases that are co-charged with violence. I believe that the primary reason is that the sample size is just much smaller for these violent cases in general, but especially there are very few violent cases that receive a null pros disposition.
Brett, could you remind us of the numbers of cases or percentages of conviction versus acquittal versus null pros? Do you have a sense of that? Because you said null pros is a pretty small number.
Yeah, so I believe Matt had that result, but it's roughly 85% conviction rate. The acquittal is roughly 5%, and then the other 10% would be null pros or other less common disposition.
Great, thank you.
And I'll just add one more note about these small ends. As I noted, when we're thinking about each column of the tracking time, 6 months, 1 year, 3 years, the number of individuals will decrease because we track more people for 6 months than we do for 1 year than 3 years. So there's some really small numbers when we start getting to co-charged with violence for 3 years for null pros. And we saw that on a much earlier slide. There was one about classes 5 through 8, and the 3-year average was 30%. And I think Brett and I looked, there were 8 cases or something total. So it just, especially on that right panel, just being a little cautious about the 3-year tracking period for smaller proportion activities or events that were invested.
Now moving on to the recidivism results by sanction type. Similar to Matt, we are looking at just 3 sanction types here: state confinement, county confinement, and probation, which again, these were the 3 most common sanction types received for these cases. The first thing we'll see is that just looking at confinement sentences in general, the recidivism rates for these individuals are much higher than those for those who receive probation. One explanation for this would be that the courts are identifying those higher risk individuals and sentencing them to confinement sentences. Looking at the nearly 2,000 individuals sentenced to state confinement for a violent docket, we were only able to track 38 of these individuals for 3 years. And again, that goes back to what I was mentioning earlier, that on your initial docket, if you're sentenced to confinement, especially if it's state confinement, many of these receive sentences upwards of 4 or 5+ years. So if we do get them at the end of their confinement period in our sample, you're looking at a relatively small follow-up period to measure their recidivism. But we don't have, that's probably the one group where we don't have great confidence in the rates is this violent group sentenced to state confinement, because we just have such a short window and a small sample size for tracking these types of individuals. And finally, looking at probation, you can see that the recidivism rates for these cases are much lower than those confinement cases across all VUFA case types.
Brett, just back on that one, and this gets to the point you and Matt have been making all along, but for probation, in cases where there's co-charge with violence, and especially when you get to 3 years, there's sort of the aggregation of all those factors you talked about. There's probably a small number of cases that get probation when there's a violent offense, and then having the 3-year period adds to that as well. So it could be a pretty small end that you're talking about in that category.
Right. And I would say in general, the co-charge with violence category is the smallest of the three categories, but especially when you're talking probation, like you mentioned. And now just looking at analysis statewide for any racial disparities in the recidivism data. As you can see here, looking across all three time periods, across all three docket types, the recidivism rates for Black individuals are higher than for whites across almost every category. For our final report, we do plan to conduct some additional analyses and try to dig into this racial disparity issue a bit further and provide some more results and possibly recommendations. But one thing to note as well is that these results are consistent with results that we've seen in the past through our own research and also through studies conducted by other institutions. Well, the next thing we did was try to take our data and connect it to the commission's data on sentencing, try to identify any impacts that the sentencing guidelines or guideline details might have on predicting recidivistic outcome. So the first metric we'll look at here is looking at recidivism by the prior record score categories. As you look across the categories here, you'll notice that there really is not a lot of difference in recidivism rates across prior record categories. And again, this is consistent with results that we've seen in the past through various research studies. The current prior record score definitions are not especially predictive of recidivism. But one thing to note on that as well is that the prior record score isn't necessarily intended to be a risk instrument. It's intended to serve as a measure as retribution and just an indicator of prior criminal histories. And again, not necessarily as a predictor of recidivism. Next, we'll look at recidivism by the conformity of sentence. So first of all, as Matt noted, many of these VUFA cases, especially as you get into the more serious dockets, do not fall within the standard range. I believe in the case of the F1, F2, and the violent dockets, it's actually less than 50% that fall within that standard range. And again, as Matt noted, the shift is typically towards the below and the mitigated ranges. So just looking at the standard range first here, you can see that these recidivism rates are substantially lower than for the other categories of sentencing conformity. I think based on sample sizes, we can sort of look past the aggravated and above categories, as we saw from Matt's research. 88% of all the departure sentences fell within that below and mitigated range. So what you'll see here, just looking at below and mitigated as compared to standard, these mitigated sentences do tend to result in higher recidivism rates across all three of our tracking periods. And just one more reminder that this is the combination of all of the VUFA dockets here. So we are not breaking this out by the F1, F2s, or the violent dockets. So next, we'll shift to taking a look at that pretrial period. So for those offenders who were granted pretrial release, we were able to track those individuals from the time of their initial court filing up until their final disposition. So again, that length of time varies from case to case, but in general, the typical tracking period pre-trial was around 1 year. So obviously we weren't able to break these pre-trial rates out by the 6 month, 1 year 3-year time periods. In this case, we are just looking at out of everyone who had a pretrial release period, what was the overall failure rate among these individuals. Again, the definition here is important as well. We're not looking at all pretrial failures. We're only looking at the failures that were associated with a new filing or a VUFA charge. So as I mentioned, the time interval we're looking at here is for those who were granted pretrial release. We're assuming that that release occurred close to the time of filing of charges. So our tracking period is going to run from the initial filing date all the way up until the final disposition date. Those who were denied pretrial release, they didn't have that same time in the community pretrial, so we did not include them in this study. And as I mentioned, the average pretrial period for all of these individuals who were released was approximately 1 year. Now, looking at these rates by all of our case types and by county classes, one thing you'll notice is that these failure rates are roughly comparable to about the 1 year rates of our recidivism results that we presented earlier. Our 1 year recidivism rates for a new VUFA or violent were right around 7% for all dockets. And this matches up nicely with those results here. So I think that's an indication that the level of risk is roughly equivalent for those who are released on pretrial release as it is for those who are released post-conviction or post-trial. The highest rates, again, we did find some differences in county classes. The highest rates of pretrial release were recorded in county class 2. And there could be a number of reasons to explain these results. One thing that's difficult in comparing these results between county classes is that each county has a different process for how they conduct pretrial releases, how they might supervise those individuals during pretrial release. So it is a little difficult to make these county to county comparisons. But in general, in our sample, we found that county class 2 had the highest rates of pretrial failure. So now moving on to our final directive, which was taking a look at community supervision for those offenders who were sentenced to probation or those offenders who were granted parole following a VUFA conviction.
I'm sorry, can I just jump in real quick with a question on the last slide? I know you mentioned, yeah, that slide. I think you mentioned there's disparities in the way each county handles pretrial. Do you have any, were you able to collect any data on the percentage of dockets who, did you do a comparison of the counties in terms of release pretrial versus confinement pretrial?
I believe we'll have that included in our final report.
Okay.
We don't have it here.
Okay. That's fine. Thank you.
And Brett, just a reminder for everyone, the pretrial data is pretty much driven by AOPC data. Is that correct?
Correct.
So we're looking at those kind of sources. And as both Matt and Brett said, if given more time, it would be really helpful to do more qualitative work in terms of meeting with pretrial services agencies, DAs, and others to discuss some of this. And just as a prequel, I guess, as we get to the discussion of the supervision period, I think there may be even more challenges in the data we are able to access. So, I think one of the takeaways you'll see from in moving towards writing a report is looking for opportunities to improve data collection, systematic data collection, so that there can be ongoing analysis of these kind of things instead of a point in time kind of analysis that we're doing now. So I think we found that to be We could have done more, I think, at pre-trial if we had an ongoing system of capturing that information and monitoring it. And you'll see that to be really the case when we get to the supervision activities while under supervision. Thanks.
So in our analysis of the community supervision, again, we had two separate samples. One was on the county level probation supervision. The second was on state parole supervision. So we're moving from AOPC data now into the county probation side. We're using a new data source for us, which is the ER2P database that's hosted by JNet. ER2P is a new system that collects county level supervision data from all the counties. Each of the counties, I believe, has sort of had to adapt some of their metrics and their measurements in order to fit, in order to be able to measure all of these different counties using the same language, the same disposition types, same violation types, all of these things. So this is an ongoing process. Not all counties are contributing data to the system at this time. And there's been a bit of an adjustment period where we may not have received every county supervision case. But we are getting more from certain counties than others. And even when we do receive information on an individual, we don't always receive the final outcome of that supervision. So we're gonna sort of be conservative with some of our results that we're presenting from this data. I won't go into too much detail or to try to draw too many conclusions. But looking across the data, we did receive data from 58 out of the 67 counties. We did not receive data from the largest county classes. We had no supervision data from county classes 1, 2, or 2A. And as we've seen from our previous analyses, these are the areas where many of these VUFA cases are occurring.
And Brett, just on that issue about data collection, one thing we want to make really clear is many of these counties have really good data collection systems locally. The issue is having statewide aggregate data that you can depend on. And ER2P has been built to try to create that capacity. And it's been going through some movements. In fact, the commission, in conjunction with JNet and PCCD, helped to support sort of the updating of the software used to correct some errors in the past. But the benefit of at least that type of system is that you're comparing apples to apples and you're collecting aggregate statewide information on probation stuff. But that's not to say if we were looking at individual counties, there's many county probation departments that have really good information systems. And we could work with counties on a case by case basis. But when you're trying to bring it all together and look from a statewide perspective and compare counties to counties, you really do need a sort of a platform to have uniformity in those kind of things. And that's what ER2P tries to do, but it's just not there yet. So as Brett said, we have to be very conservative in what we're saying about this and just point this out as an area of future development.
And I do believe that the ER2P system will be a very good research tool and analysis tool for us. This has sort of been a gap in the data statewide. Is trying to get at this probation supervision data violation rates. It's not been easy data to get a hold of in the past, and I think with the ER2P system, we'll have a much richer data set for these county supervision cases than we have in the past. But for this time period and for these VUFA offenses, in the end, we had 456 individuals who were sentenced to probation that we were able to track their supervision periods from the ER2P system. So again, this is a much smaller sample size than what we had for our 43,000 individuals in the overall recidivism study. But just looking at the basic probation outcomes, the dispositions that we were able to extract from ER2P. Number one would have been a successful completion of the probation period. And then we had two revocation types, either those who were revoked on a technical violation or those who were revoked on a new charge. This could have been any charge that led to a revocation of probation. And then finally, there were some other dispositions that were related to transfers to different jurisdictions and things of that nature. And again, I'll mention the sample size. If you go down this list of disposition types, we're under 100 total cases for each disposition, except for the successful completions. One thing we will note is that the overall rate of successful completion is around 70%. And then looking at the revocation rates, the combined revocation rate is approximately 15%, with the 16% others. And technical revocations are somewhat more common than those for a new charge. And again, the sample size is extremely small here, but we did see we did see that Black individuals were slightly more likely to receive a technical revocation than for white, but it's really difficult to put too much weight into that finding. Now looking at the state parole supervision data. So this data was a combination of Department of Corrections prison release data combined with the parole board's records of state parole supervision. So we did have a larger sample size for this set. We looked at 81,000 individuals who were granted parole for a VUFA docket for a VUFA conviction from 2015 to 2020. Now, again, looking at this in a similar format as we have been, we got the county classes on the left. Our first column is for all parolees. So these were not necessarily the VUFA parolees, just the overall parole violation rates on the left. And then on the right are the VUFA dockets that we've been studying in this resolution. So first of all, just looking at the overall statewide rates, we can see that there's not a substantial difference in violation rates between all parolees and those VUFA parolees. Relatively similar rates here. And then going down, looking across all of the county classes, again, you'll see that the violation rates for all parolees and for those VUFA parolees are relatively consistent across all county classes. County class 2, again, is slightly higher than the other counties, but I don't know that it's a large enough difference to call that a key finding. Now, looking at the results we've been able to draw from our directives 5 and 6 from the resolution, we have been able to learn a few things by taking the charging data from Matt's research and bringing that through to the final outcomes of recidivism. What we found was that recidivism rates do vary by county class. In the areas where we saw the highest recidivism rates were in county classes 1 and 2. And there seemed to be maybe an urban versus rural split in terms of the recidivism results. Our next finding was that recidivism varies by race. Black individuals had a higher recidivism rate than whites across nearly every category. Again, this was not a surprise from this study. We've seen similar results in recidivism studies across many different jurisdictions and time periods. One thing we found was that the specific VUFA offense that an individual was charged with didn't seem to have a substantial effect on the recidivistic outcome, with the exception of those felony 6105s, which again, these are the individuals who were previously convicted of a felony or a violent offense, and now are recharged with a VUFA offense. Again, our probation data was very limited, but based on the data that we did have, we found that Blacks were more likely to receive technical violations than were whites. And finally, looking at the state parole data, we found that state parole violation rates didn't vary substantially by case types, whether they were all parolees versus VUFA. They didn't vary by race, and they didn't seem to vary by county classes either. So the parole data was very consistent across the board. So I think, as we mentioned earlier, we'll continue to run additional analyses and finalize these results over the next month as we complete the final report for House Resolution 111 by June 30th. So we're more than happy to take any suggestions or feedback you might have on the results to this point, and see if we can tailor our analyses as we head into these final 4 weeks here. And then I just want to acknowledge the work of commission staff in the preparation of this data, especially Jordan Svankovich, who is one of our analysts who spent countless hours over the last few weeks trying to tie together all of these data sets. As I mentioned, we have data from 5 different sources for this study. It's not always easy to tie those things together and draw conclusions. So I just want to thank, again, the staff for all of the work in putting all of this research together. With that, we can discuss, and we'll take any feedback that you might have.
Hey, Brett, thanks. And I'll turn it to the judge to get us back on track with that. I did want to make just a couple of comments. And again, it's about recognizing staff and all the work that went into this. This is a pretty tight time frame. The resolution passed at the end of last year. And so it's been a lot of work in a short period of time. So staff's done an incredible job. And one of the other things that we really built on was the research partnership we have with Penn State, having some of our postdocs and others working on this. So it's been a great project. I give Matt and Brett all the credit for all the work that went into it. I did want to recognize 2 data sources. First, the Administrative Office of Pennsylvania Courts. We really benefit as a Commonwealth from the work that the AOPC has done in building and developing both of their data management systems, the MDJ system and the Common Pleas Case Management System. We could not have done this without their data. So they're an incredible partner. They have been for many years, and I just wanted to give them credit because it's important work, and we couldn't have done it without their data. The second thing I want to recognize is all of the work of the Pennsylvania State Police in trying to make available and sort of rebuild their system to provide us with access to arrest information and other things like that. We weren't able to use it this time, but we've been working with PSP to improve the method by which we can obtain information from them. And we know that they're on track to really be a partner in the future on some of our research projects. And it was unfortunate because of the timeline and other things like that we couldn't take advantage of that for this study. But for future studies, I'm really confident that the work PSP is doing to rebuild that system and make it a better process for obtaining information for studies will be there. So I just wanted to, I know we didn't use them for this study, and that was noted, but I wanted to mention all the work PSP is doing to help in the future. So with that, I'll turn it back to the judge. Thank you.
All right, Representative Krajewski, I believe you have a question.
Yes, thank you, Chair. And thank you, Brett, for the thorough presentation. I just had a couple questions and then a comment. On the findings, it says there that particularly around recidivism rates and technical violations, that the findings show that Black people are more likely to recidivate or or to have a technical violation. Are there any initial thoughts or guesses as to why that disproportionality is there?
Yeah, I'm not sure we have the necessary contextual data to fully answer that question. But I think some of the things we can think about are that we saw the majority of these cases are coming from county classes 1 and 2. We know within the states, our highest populations for Black individuals are in some of those county classes 1 to 2A. So there seem to be some connections here where that's where we see the majority of these cases. That's where we see the higher recidivism rates. And so I think what we hopefully do in future studies is try to get some of that contextual local level information, talking to local officials and learning how those processes are working at the local and county levels.
Thank you. Yeah, I think because you're right. In looking at the data, it's clear that there's differing percentages in dynamics, it seems, between urban, exurban, rural, et cetera. So it seems like trying to figure that out, that more granular data in the future would be helpful. And then 2 other thoughts I had is, at least speaking anecdotally here in Philadelphia, we definitely have seen a uptick since COVID, and I am wondering if there are any plans to try to also lay the data out in terms of pre and post pandemic, and seeing if there's any findings to be made there in terms of the role of COVID in terms of the increases in gun violence. And then the last thought I had was just, especially knowing that in some of the other class cities beyond 1st and 2nd, that we have an increasing Latinx population, thinking that it would be helpful to also see the racial categories to include people of Latinx descent and what those trends might be there too.
Representative, let me take a first shot at a couple of those and then throw it to Matt and Brett. On the one issue, the issue you just raised about Latinx, we've been working, in fact, with one of the postdocs that we have in trying to really improve or think of ways to improve the quality of our data and data that we work with in terms of race and ethnicity. And one of the, I guess, limitations is we generally, as a system, capture information at the time of arrest, and that information moves through the system. And sometimes it's updated and sometimes it isn't. So we're trying to figure out ways to more accurately reflect race and ethnicity in the information we either collect or that we obtain from others. And then there's oftentimes when there's conflicts where we'll have multiple sources of data about an individual, and there's differing, race or ethnicity findings. So we have to work on that. But as you may recall, the most recent postdoc that we hired was hired around the issue of looking at race and ethnicity and other kind of concerns about that in the system. So we'll continue to work on that. And I think you're right. The Latinx population is one of those areas where I think it's probably weakest in terms of data. And there's a lot of work that has to be done on that. Regarding COVID, and this is a separate issue for the commission, but we have not released our 2020 annual report yet, and we're working on our 2021 annual report. But one of the reasons for that is the impact of COVID, and we've ended up sort of seeing it as a 2-year package. And Matt and others have done some really good work doing some analysis of the impact of COVID on sentencing and on court operations. And so we're looking at a sort of a 2-year annual report where we look at the COVID period, and we try to take away from that some of the impacts on courts and the impacts we've seen in terms of convictions and sentences. And we think there's a story to tell there, but we think also, lessons learned or things that we can figure out about the COVID impact apply to things like this, with looking at VUFA, looking at racial disparity, looking at a lot of other things. So I think you raise a really important issue, and we need to have some lessons learned from what we've gone through. And I think this will be part of it. So on both of those counts, I'm glad you raised them. We'll do what we can for this report to the degree that we can answer some additional questions, but really limited on time and ability. But I think as a long-term process, we have to make sure both of those are on the table. So thank you.
Thank you, Mark.
I'll just add on one more note, what Mark just mentioned. So if we assume that COVID sort of started in March 2020, our end date for our data collection is December 31st, 2020. And obviously we're tracking folks for recidivism. It doesn't leave a lot of time there for processing and then anybody who has confinement sentences. So I think it's a great suggestion and something that we will continue to explore if that's something the commission would like us, but probably not from very meaningful from the data that we have as an interruption, given how late it is in our data set and what we're using as metrics for following up.
So basically, it's just only like an 8 or 9 month overlap in terms of the data collection. Got it.
Correct. And those would be the filing of new cases, not even the dispositions of those. And then what happens to them, for some tracking period related to pretrial failure or for recidivism. So it'd be a very tiny window for that.
Right. Sure. Yeah. No, I get that. That makes sense. Yeah. No, thank you for clarifying. I think with being able to have those findings moving forward will definitely be helpful. That's all I had for now. Thank you.
Thank you, Representative. Is there anybody else with any questions or comments?
I do have a question. If someone could refresh my recollection regarding the reporting for county probation, is there the same type of penalty for failure to report as there is for sentencing information?
Judge, in the data set we were using this JNet function, there's no penalty for that. It's a service that's available. I think a lot of counties are trying to use it. There's a benefit to using it, but I don't believe there's any specific penalty. There are some sort of accreditation programs in place for county probation. I'm not sure that reporting through to ERP is part of that, but we can check on ways to improving it. But like I said, I think there's a lot of counties are participating, and there was a glitch in the software that we helped to support counties in upgrading and fixing. So I think it's just more about recommitting to having this, and then looking at those handful of counties that aren't reporting and figure out if there's what's the reason for that? Is it a technology issue? Is it a workload issue? What is the reason? We can always sort of look at counties and try to get individual data and compile that, but that becomes more complicated. So I think, the solution is trying to use this product that's available. And so we'll look into, why counties aren't participating and see if we can build on that. But I'm not aware of any penalties or other things, disincentives or incentives to make it happen.
Yeah, it seems like the most two important counties that should be reporting are not reporting. And that concerns me, especially the first class county with the uptick in violence and gun violence in our city. I think that's important. I feel certain that if they were nudged, even if it was a phone call from someone, which I'm going to do today, that the reporting will happen. I'm certain of that.
Sure. And Judge, just to not to make excuses for probation and parole, but there were sort of groups of counties that were using a software package, and maybe there were 2 or 3 different software packages that were sort of common among county probation and parole in terms of case management. And so it was sort of easy for all those counties to get on board because you sort of had a single vendor that could update their software to, make it work with this application that was available. But there were other counties and especially larger counties that had sort of homegrown case management systems. And those might have been a little bit tougher to align in terms of reporting their data through this system. So yeah, I think nudging is great. And I think we should do what we can to help counties to do that so that we have sort of a statewide picture. But we also, if we were going to do this study again and we had, more time, I think we try to just get individual data sets from counties, because I'm sure Philadelphia and other counties that aren't reporting through that system could have provided some data that we could use. It was just, we were pretty much pressured for time. And the only statewide system we had was the one that again is going through some bumps right now, but I think it's coming through. So thank you for your nudging. And I think we'll continue to work with counties. Thank you.
It didn't happen yet, but it will.
I get it.
Okay. Thank you.
Thank you, Judge. Are there? DA Sunday, go ahead.
Quick question. This might be more of a comment, but when you're looking at the impact of COVID on gun violence, this is something that I often wonder based on my experience of what I'm dealing with right now in York City, where I'm the DA. And that is, what is the correlation with the time period when schools were closed? And I say that specifically because I know for a fact that there's a lot of children who, due to the circumstances they're in, rely heavily on school for food, for attention, for love from teachers. And I know anecdotally that, and what we're seeing are a lot of the uptick in violence are children who otherwise may have been in school. And I'm not saying there's a correlation or not, but I just often wonder what the impact of having children not having been in school during that time period was on their circumstances and what sort of became of them as that year went on, and whether or not that had an impact or not on their criminal activities that they're involved in now.
I'll just mention, I think that's a great issue to look at as we're, especially on this like 2-year view of COVID. I think that's something we probably haven't looked at, and it might be something we can partner with JCJC or PCCD just to try to look broadly at that issue. I think it's a great thing. Thanks.
And Representative Stevens, I think you had a question or a comment.
I did. Thank you, Judge. Great work. And I know it's been, I know the timelines are short, so I'll ask this. How hard is it? I think you had some slides, Matt, in particular, showing the decrease annually in the number of, I guess it may have been an increase annually, the number of null pros cases from 2015 to 2020 in the first and second class counties. How hard is it to take a look at the trends concerning guideline conformity by year as well? Is that difficult to do, or is that something that could be done easily?
Yeah, we could do that easily. So we'll certainly add that to the report for that section.
Okay. And I guess if you could, and this kind of goes back to one of the comments Judge Tucker made, that one slide was great about guideline conformity, but maybe if at the end of each of the graphs, you could put the number.
Sure. And the report will have the raw numbers. This was my attempt to make it easier to see, but maybe failure, I should say.
No. I thought it was great to show the comparison. I thought it was terrific. And I think so. Just like way of quick, sort of brief summation. It looked like the first and second class counties had higher withdrawal rates in the lower court, higher null pros rates in the court of common pleas, and it seems like both of those were consistent with higher recidivism rates as well. Am I right?
Correct.
And then it also seemed, and I know we commented on sort of the significant number of cases in the first and second class counties that were being sentenced below the standard range. And I forget, was there an analysis about those cases that were below the standard range and the recidivism rate?
Yeah, we did present the recidivism rates by conformity to the guidelines. And what we saw was an increase in recidivism for those below and mitigated sentences.
Okay. All right. Thank you. Your work is terrific. I appreciate all the data. It's very helpful and look forward to the report.
If there's one thing I could add that might get to some of the differences in either county class or just county specifically and how the attrition works. We did prepare a summary of local rules by county of how cases were processed and which counties had requirements for the DA to approve charging versus not, or approve charging for certain offenses versus not. And that's one thing that we can look at a little bit more, try to include in the report, because that could explain some of the things. Since we're using initial charging data, if prior to that there was a filtering of who was being arrested for certain offenses, and that didn't even make it to the charging point, that could impact or just influence some of the dispositions or some of the movement of cases. So we have to see what we can do, and at least knowing generally what the rules are, I think we might be at least able to say if that could or could not be one of the impacts. But as Matt said, it would be helpful if we could do more qualitative work, and so we'll put together a report, and we'd appreciate any comments from members about other specific things that should or should not be there. But I think at the end of the report, we do want to sort of draw a sort of a line of how these cases are moving, and then the recidivism. So showing the full picture so that you can see it all in one place. And then also have some recommendations, and particularly about ways to improve the system or ways to improve the ability to continue to study these things instead of it just being almost an ad hoc kind of thing. And that gets to systematic data collection. So those are things we can do, but we're open to any other suggestions from members.
One other question I had regarding how difficult something is. I know there's been some conversation about the some of the racial data, and the comment that's, I think, fair, that based on the composition of some of those counties, that may indicate why the data is what it is. Is there a way to analyze that? I mean, take a look at the racial makeup of the different counties to discern whether this is just simply, these increases are a result of just the racial composition in that particular county? Is that hard to do? Is that something that can be done?
I think one thing we could maybe do is take a look at census figures for various population rates across counties and try to tie that into the results that we have from the study. But again, one thing we know from the study and previous studies is that the Black individuals have higher rates of recidivism and higher prior record scores, and that obviously has a big impact on the sentences they receive.
I guess there's other data that we don't have. Like, I'm just thinking about economic data and things like that might also be factors here that we don't have the ability to really measure. So I guess we have some other blind spots, in this regard as well. Well, I mean, it's certainly some food for thought, and it maybe ties into some of the data collection issues that Mark raised earlier, and something for us to think about as a commission moving forward.
Any other questions or comments? I just wanted to say thank you to Matt and Brett and Jordan for the daunting task that you undertook and so successfully have put together. That is very impressive. I think just by our short discussion, it answers some questions, and then it creates a lot more questions for us to explore. I just wanted to comment that one of the results of your study is the recidivism by prior record score was very telling in terms of the percentage of new VUFA offenses didn't seem to be impacted by an individual's prior record score. So that to me was not what you would have expected to see, but it goes with what we're talking about with the 8th edition in terms of our modifications of prior record score. So I think that that's a really good piece of information. So I think you two are off the hook for any more presentation. And with the period of time we have left, I'm going to turn this over to Executive Director Bergstrom. He's going to talk a little bit about the parole and recommitment guidelines.
Great. Thank you, Judge.
Sure.
And I'll note and keep this under 10 minutes, but during our dinner meeting last night, the commission started a discussion of the working draft of the sentencing guidelines. This was the draft that we published in the bulletin in January and then had 6 public hearings. And we have posted on the website and of course provided to all members just some initial information, sort of highlights of some of the comments received. Of course, members received copies of all of the testimony received. But sort of highlights of takeaways from the sentencing guidelines discussions and sort of a starting point for putting on paper some of the ideas raised and maybe some concepts or some direction we might want to take. And so there was a discussion last night during the dinner meeting of holding a work session or two by commission members to sort of dive into that and start working on draft guidelines based on what we provided and then what we heard and some additional analysis by staff. So we'll be talking during the commission meeting about trying to identify a date or dates to have a work session with members to start working through those details. The other thing related to that is the idea of really re-engaging with people in the community as we continue to rebuild these guidelines. And so we certainly want to meet with important interest groups like the Trial Judges Conference, the DA's Association, the Public Defenders Association, the victims community through OVA or others. So there's a lot of specific associations or offices that we'd want to meet with and talk to just to make sure we're hearing from them about issues or concerns or directions we might consider. And then also just meet more generally with practitioners. So the idea of having some regional meetings that we open up to practitioners, in the Southeast, in the Northwest, whatever, just to provide another opportunity as we're working through these, because we want to keep driving towards putting together draft guidelines that the commission can consider and receive more detailed comment on. I do want to just mention briefly in the materials that are posted and were distributed last night and discussed, at least as an initial discussion, there were a number of takeaways about sentencing guidelines that I wanted to highlight. One is information on just the offense gravity score assignments and sort of general rules that the commission uses and also specific assignments to types of dispositions. For instance, one of the comments we received was a real, I think, support for a new category that we created that is exclusively other restorative sanctions, not probation, but other restorative sanctions. And while there was support for that, there was also concern that we didn't assign a lot of offenses to that category or dispositions to that category. So I think one of the things we'll be looking at is, are there more offenses that are appropriate as first-time offenses or repeat offenses down at that level to really promote the use of those other restorative sanctions. We heard about probation, that best practices would really limit the recommendations of probation to 2 years rather than 3 years. And so reducing the number of categories for probation might be appropriate, but also building into it as required by statute, the consideration of when use of restorative sanctions is helpful and taking advantage of information on risk, needs, and responsivity. So all of that, I think, we're trying to incorporate in. And then at the county jail level, There was a discussion of providing courts with a little more latitude, so a little broader ranges, maybe some overlapping ranges, maybe not quite as many categories. And so we've incorporated that into some of the mix. But the one area that's the most complicated and the commission is going to be spending a lot of time on is just thinking through prior record score, because fundamentally the reason many states have guidelines have a prior record score is either because of retribution, because someone's coming back into the system and there should be some recognition of enhanced penalties or whatever because of that, or because of risk, the sense that, past is prologue, and that there's some indicator of repeat offending or potential for repeat offending if someone has priors. We've been working really closely with Carnegie Mellon University to really investigate that prior record score part and the degree to which risk could be a part of the prior record score. But I think we also have conversations separately about how do you take into account retribution, accountability through the prior record. So that's one of the things the commission will be discussing about, what is the purpose for the prior record score, and then how do you compose it that addresses some of the concerns that we heard. So a lot of work there. The final thing with the prior record score are the various categories of the prior record score, and there was support from the comments of perhaps adding another prior record score category. We tried to reduce from 8 to 4, now maybe go up to 5, but trying to find the appropriate number of prior record score categories that capture and support whatever policies the commission's trying to address. And with prior record score, an area where there was a lot of support was the commission pursuing greater lapsing provisions, where old or stale records go away. But there was a real split on how you would do that. I think there was a lot of support to really focus on less serious and older records, and those would be sort of the target of lapsing, and a lot of concern about lapsing more serious or violent offenses, sort of categories of offenses that maybe should be excluded from lapsing, or that there would be a really long period of time before lapsing might occur. And then there was also the discussion about whether lapsing means just a decay period, like a look back period. Once you get past that look back period, something goes away, or what we call a gap, which means there's law abiding behavior during that period. And there were concerns about juvenile adjudications versus adult convictions. The Juvenile Court Judges Commission suggested that perhaps the commission should consider increasing the age at which offenses, juvenile adjudications are considered in the prior record score, increasing it from age 14 to age 16. So a lot of things to look at. So during the meeting today, we'll be just talking about potential dates for a work session or two to have the commission work through some of these issues, and then engaging more broadly with the public, with a lot of groups over the summer to do this so that we can move towards a little more clarity during the September meeting. The other thing I wanted to touch on in closing were the parole guidelines and recommitment ranges that we just finished 2 days of hearings on. And I think, we received some really helpful comments. Some comments I know were sincere and intended to be very helpful, and but sometimes sort of fell outside of our statutory mandate. So one of the things was that there are concerns about use of risk assessment anywhere in the criminal justice system, and particularly in the parole guidelines. But on the other hand, our statute requires us to use a validated risk assessment instrument within the parole guidelines. So we have to meet the statutory mandate, but we should be careful about how we do that. So we've had a lot of discussions about the instrument being used by the Department of Correction, the LSIR, moving to the strong R. We can have more discussions about that, but I think the takeaway that's important to remember is the LSIR is being used right now. The parole board has their own internal instrument, and they use the LSIR as part of that. what the guidelines are trying to do, and we don't have guidelines in place for parole yet, but the idea with the guidelines is to put in place something that would be more transparent, that the public would better understand, and the individuals being reviewed for parole would understand factors in play and the weighting of those factors. And there'd be a system of capturing data about what's happening. So we as staff, I think, see as an important step the adoption of parole guidelines so that we can start this process with the understanding that, we'll have to update these guidelines when there's a new instrument, but we have to start at some point. And I think the same could apply to the recommitment ranges, except with those, what we're really trying to do is just codify a practice that is already in place with the board and put in place a mechanism to capture data, because we really have limited data on current practices about recommitment, and we have to start somewhere. And so we see these as sort of interim guidelines to get us started. The final thing people were concerned about, and rightly, was impact of parole guidelines or recommitment ranges, an impact in terms of confinement and impact in current terms of race. And one of the things that I'd encourage individuals that raise the concern about race is to look at our website and the information we have posted from 2020, when we first put out the proposals and provided information on the building of the parole guidelines. And there we did a pretty thorough analysis looking at the impact in terms of decision making, in terms of race and other things like that. So those materials are on our website. I encourage people to look at those. And we'll continue to work with the board in trying to look at recommitment and whether there's information related to race and outcomes related to recommitment. But during the meeting today, we'll just recap some of these and ask the commission to make decisions about how to move forward, both on parole guidelines, recommitment ranges, as well as next steps for the sentencing guidelines. Thank you.
Thank you. Any questions or comments? All right. I believe based upon that, then our policy meeting is adjourned.